this is Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I'm going to be talking about medical records for physicians and what they need to do with them when they retire or sell their practice. Under Tennessee law, medical records belong to the physician. And when a physician decides to retire or sell his practice, he can sell his medical records as part of the transaction to the purchasing medical practice. But there are a couple of things that the doctor who's selling his practice and transferring the medical records needs to keep in mind. Number one, Tennessee law requires that when you are transferring, when you're retiring and your medical records are going to be transferred to another custodian or another doctor who will have control of those records, you must notify all the patients whose records you're transferring if you've seen that patient at least if you've seen that patient within the past 36 months, unless you've seen that patient fewer than 2 office patient encounters during the last 18 months. So you have to look at all the patients that you have, determine which patients you've either provided services for or consulted with over the past 36 months, and you need to notify all of those patients unless a patient did not come in for an office patient encounter at least twice within the past 18 months. So once you have your list of patients to notify, you have to notify your patients, give them notify them that you're retiring, you're selling your practice, whatever, and where those records are going to be, and give them the option to get a copy of their records sent to their physician of choice. It may or may not be the person to whom you're selling your practice, and so if they decide they want to get their own doctor and it's a different doctor from the one you're selling your practice to, you have to give them that option and provide a copy of those medical records to those patients. So that's number one. You have to notify your patients if they fall within a particular category of having been treated by you or seen by you in the past 36 months. That's number one. Number two is you have to comply with federal law, which is, in this case, would be HIPAA, the Health Insurance Portability and Accountability Act of 1996, HIPAA. And so HIPAA does require that if you are going to be sharing information that's protected health information of your patients, which you would be by transferring your medical records to another doctor, that you have to and essentially keep those records secure. And the way you do this, if you're making a transfer to another doctor, is to enter into a business associate agreement with the other physician who's buying your practice and buying your medical records, to make sure that they are under the obligation of confidentiality with respect to those records. Because what's going to happen is the doctor who's buying, or the medical practice that's buying your medical records, some of those patients may become their patients, in which case they're going to be under just the general HIPAA regulations and requirements with respect to those medical records because they're treating those patients. But it may be the case that the doctor or the medical practice you're selling your records to is simply just going to be the custodian of those records, and those patients may see other doctors or may actually ask for copies to be sent to other doctors, in which case the doctor to whom you're selling the records still needs to comply with HIPAA and keep that protected patient information safe and secure and confidential. So you would, number one, notify your patients when you transfer the records, give them the right to notify them of the right to get a copy of their records sent to their physician of choice. You can let them know that you're selling your practice and retiring, and they may wish to contact that physician. If so, that's where the records will be. And second, you should, as part of your transaction with your purchasing doctor or medical practice, have a business associate agreement with that doctor or medical practice. Could be part of your purchase agreement, but you need to have that in writing with that other medical clinic or physician to make sure that they are going to comply with HIPAA with regard to the medical records and the protected personal health information of the patients that you acquired during the time that you were practicing. So essentially two steps. One is make sure you notify the patients. Number two, make sure that you've taken into account HIPAA and you've got that business associate agreement with your purchasing physician. All right, I hope that helps. We'll talk to you again next time.